company makes payments to a related party of its shareholder, and the company doesn't receive anything in exchange from this related party, are these payments dividends or are they donations? This is the question I'll be discussing in this first episode of Tax Break for 2026. I hope that you are all well rested and ready to see what the year holds in store for us as tax professionals and practitioners in South Africa. Before I delve into the question, I want to ask you if you would be willing to share this episode with another tax practitioner or professional who you also think might be interested in listening to the podcast. So maybe to share with you, with your help, this podcast has grown to, we are very close to 1,000 subscribers. And I think even more regular listeners who are not necessarily subscribers. So it would be very good if that trend can continue into 2026. Right, so back to our scenario. A company has a shareholder, but it pays an amount not to that shareholder, but to a related party of the shareholder. And the company doesn't receive any consideration back from the related person. The question is, what is this amount? So this question is, or this issue is not a new one. I've already covered it in a previous podcast. For those of you who are regular listeners, you can go back to episode 34. Now, in that episode, I looked at some of the commentary from SARS and the National Treasury around this. So in this case, we're going to look at it a bit more practically in the context of a scenario in a recent ruling. So binding private ruling 423 that was issued by SARS in November. The facts that were presented to SARS for purposes of the ruling is that the parties involved is a trade union. Now, important, the trade union is exempt under Section 10(1)(d) Roman 3 of the Income Tax Act, a trust that was founded by the trade union, and a company whose shares are held by the trust. So, to maybe add a bit more color to the picture, the trust holds all the shares in the company. The trade union as the founder is also of the trust, is also the sole beneficiary of the trust, and this is a discretionary trust. So what the facts in the ruling suggest is that this structure was put in place to invest the trade union's surplus funds. So the principal object of the trust, amongst others, is to apply the investment proceeds from the investments made by the company for the benefit of the trade union or its members. So the transaction that they approached SARS for a ruling is that the company now intends to pay annual amounts to the trade union to assist it to cover its operating costs. So there's going to be no consideration flowing back from the trade union to the company. And remember, in this picture, between the company and the trade union sits the trust that's the shareholder of the company. So with all of these rulings, it's always good to think about what could the reason be why the parties requested the ruling. So the one reason I can think of is that if we look at the trade union, one's first instinct is to say, but it's exempt, so why does it matter whether it's a donation or a dividend that's being paid to it? But if you look at it a bit more closely, if it's a donation, there's an exemption for any donation made to an entity listed under Section 10(1)(d). So that exemption we find in Section 56(1)(h). However, if we look at the dividends tax exemptions, the exemption only applies to fidelity funds or indemnity funds in Section 10(1)(d) Roman 3. So not all the entities listed there. And one of the entities that is they're not a fidelity fund or an indemnity fund would be the trade union. So I suspect the one reason why it was necessary to get a ruling is if it's a dividend, it may not be exempt from dividends tax, but if it's a donation, it would be exempt from donations tax. Okay, so the question then, is it the dividend, is it the donation? And I think the right place to start the discussion before we go and look at what SARS ruled is to look at the definitions again. So if we look at the definition of a dividend in section 1, it's any amount, and then there's a specific exclusion for certain dividends arising from transfer pricing that we're not going to look at now. So it's any amount transferred or applied by a company that's a resident for the benefit or on behalf of any person. So it doesn't specifically say it's only the shareholder in respect of any share in that company. So if it's paid by reason of the shareholding in the company, whether the amount is then transferred or applied by way of a distribution or as consideration for the company acquiring the share back from that person. And then the definition goes on with a few exclusions that are not relevant for now. Right, so that's the dividend definition, and I think what's clear there from this definition, two things. One is that this amount can be paid to any person. It's not limited to the shareholder only. And the second is it must be paid in respect of the share. So there must be a link between the payment and the shareholding in the company. Right, if we then contrast that to the definition of a donation, so that definition we find in section 55, that definition states that the donation is any gratuitous disposal of property, including a gratuitous waiver or renunciation of a right. So what's the key difference between these two definitions? I think it really all comes down to the reason for the payment. If the payment is linked to shareholding, so that's the reason why this payment is being made, then we are into the definition of a dividend. If it's a gratuitous, if the motive for the payment is gratuitous, then you are looking at a donation. So in the earlier episode 34, I looked at the SARS and the National Treasury commentary, and the conclusion was really that the same to say, but if this linkage is there to the shares of the company, then it's going to be a dividend. And in binding private ruling 423, SARS consistently with this confirms that the payments will be considered dividends. They are not donations. So that's consistent with the commentary. Now, interesting, and that might be the second reason why it was necessary to get a ruling in this case, is that the commentary suggested that there could be scenarios where you've got a dividend and a donation. So the reason why that would happen, and you can listen to the earlier episode for that, but the dividend is the first flow, but the second flow of value is that the shareholder to whom the dividend would naturally accrue in some way also now transferred that amount or the value of the dividend to someone else without getting something from them. So that second transfer is then the potential donation. Now, I think in this context of the trade union, the trust, and the company, what makes it a bit different is that if that second transaction happens, that's arguably a distribution made in accordance with the trust deed, and that wouldn't attract donations tax. So what's the take-home message? I think a few things that you can consider. Firstly is that there is a presumption against a donation in law. There's case law that really says that it's not human nature to ordinarily part with something for no consideration. So if someone alleges that they've made a donation, it's for that person to prove that they've made a donation. What the ruling and then also the earlier commentary suggests, and it's a reminder for us, is that if there's a link between the recipient of the payment and the shareholder of the company, the reason for that payment is very likely the shareholding in the company, in which case the payment would be a dividend. So the mere fact that the payment goes to a person other than the shareholder is not sufficient for it no longer to be a dividend. And then the third point to take home, as I've already said, is that this same transaction may in some circumstances also trigger a donation depending on the facts and circumstances. That's that for today's episode. I just want to remind you that the podcast is only for information purposes. It's not intended to be tax advice. Until next time, goodbye.